BB versus Harrington. Ms. Boudreaux?
Good afternoon, Your Honors, and may it please the Court, Kimberly Ulasiewicz Boudreaux, appearing on behalf of the Louisiana Department of Health and its Secretary. The District Court's class certification order must be vacated for several reasons, but today LDH is going to focus on the four biggest problems, which are commonality, the lack of typicality, ascertainability, and cohesiveness. This is LDH's second appeal related to the class action. We were here 2 years ago, as you might remember, Judge Engelhardt, because you were on that panel. And in that instance, the Fifth Circuit agreed with us that a class of Medicaid children that pertains to those recommended for something called intensive home and community-based services was not ascertainable. In that first opinion on LDH's first class certification appeal, the Fifth Circuit only discussed the ascertainability issue. It did not address the remaining defects in class certification. So we're back here 2 years later, once again arguing that ascertainability is not met, this time because a class of Medicaid individuals who are recommended for something called intensive behavioral services is not ascertainable. But what LDH is most eager for this court to rule on is the lack of commonality, typicality, and the lack of cohesiveness. Because even if the plaintiffs limit this suit to specific services and the parties can come to that agreement, there still lies the issue of commonality and typicality, and that preventing meaningful relief from being issued in a single injunctive order.
Counsel, let me ask you at the outset, based upon the prior appeal, is it the position of the department that the class description must include the list of billable services? It seems to be what a lot of the briefing discusses.
No, Your Honor. Our position, we believe that let me rephrase that, Your Honor. We believe that the Fifth Circuit's opinion in the first appeal clearly dictated that the district court mandate that the specific services listed are billable, and so we believe that in order for them to be identifiable, they need to be billable, which means any provider, whether you're in public or private health care, has a billing service that they bill for in order to get paid.
So billable does not necessarily mean that there has to be a reference to the billing codes.
Yes, capable of being billable. In the past, if there was a circumstance where providers were recommending a service for Louisiana children, and let's say that Medicaid in that instance didn't cover the service, then LDH's position is that we would do our part to help create a service that could be billed, possibly within the billing codes that are already there, in order to provide that service to children. So what LDH is saying is that they're currently in the lower court proceedings and in the discovery phase, there's been no evidence of a service that's been recommended for a Louisiana child that LDH is not providing or through its health plans. I want to start with talking about the biggest issue, which is commonality. So after Walmart, there was a heightened standard in order to satisfy the commonality requirement. The two standards being they need to suffer the same injury and there needs to be a common contention that's resolvable on a class-wide basis. So we know that these plaintiffs have not suffered the same injury. They're not alleging that they've been deprived of the same service. Interestingly enough, as of October of 2024, all of the original named plaintiffs, so A through F, who were in the suit in May of 2021 when the class was originally certified, has since left the suit or have asked to be voluntarily dismissed. So the remaining four plaintiffs, the district court has not reviewed any evidence related to those remaining four plaintiffs, and certainly not their legal claims and defenses.
Would it have been sufficient to say that the class of plaintiffs are those who have, obviously fall within the age group, but those that have been deprived of all or some services that the federal law mandates?
Well, the federal law doesn't, this case would be easier if it was talking about one specific service. But the federal law, the EPSCT mandate, which stands for Early and Periodic Screening, Diagnostic, and Treatment Services, that mandate in and of itself is subjective, because in order for a Medicaid child to be entitled to a service under the EPSCT mandate, it needs to be recommended by the child's provider as medically necessary, and two, it needs to fall under it needs to be listed in 1905A of the Social Security Act. So there's no universal benefit to a service under the EPSCT mandate or under Medicaid law. It needs to be recommended as medically necessary and listed in 1905A of the Social Security Act.
But the state agreed that the first two categories were adequately described, first two categories of this description?
Yes, at this point in the lawsuit, Your Honor, because after the appeal, the parties were in court-ordered negotiations, and we were able to come to an agreement with plaintiff's counsel as to the specific services implicated with the 2 of 3 umbrella terms in the class definition. So the parties now agree that crisis services relates to mobile crisis response and intensive care coordination. We agree on the services that are limited under that umbrella. The third service umbrella listed in the class definition, intensive behavioral services, that's a term that the parties do not agree on. Plaintiffs have already—
Seems to be some pushback on the word intensive, but you've already agreed to intensive care coordination. You just don't agree with intensive behavioral difference.
Yes.
So if there's an issue with the word intensive, why is it an issue? Why is it problematic with regard to behavioral services, but not with care coordination?
So for intensive care coordination, that is more of a term of art in Medicaid, and we can identify services that qualify under intensive care coordination. We have CMS guidance that discusses intensive care coordination and says that a synonym for it might be wraparound facilitation, which Louisiana has through one of our waiver programs. We also have something in our contracts with managed care organizations called tiered case management, which provides intensive care coordination. We don't intend to be petty by arguing over that word intensive. It's, do we know what you're referring to when you say it? And for intensive care coordination, through the court-ordered negotiations, we have figured out what plaintiffs are referring to and can move forward as to the ascertainability of that term.
So it looks like the district court set out 10 or 11 categories under the intensive behavioral services. What more could the district court have done?
So for the plaintiffs retained an expert that said intensive behavioral services itself is a single billable service. LDH was surprised to hear that because we're not aware of any provider in Louisiana recommending something called intensive behavioral services. Our expert said, we can agree on your general description of intensive behavioral services. Generally it's helping a child who has a mental health condition rehabilitate to a functioning level in the community, at school. We agree on that generic description. We just don't agree that it's a single billable service. And LDH's expert said, here are 17 services in the Medicaid program that could fall under your definition of intensive behavioral services. The plaintiff's expert listed several components that presumably make up the one service of intensive behavioral services. And those components, and I'm paraphrasing here, said things like, if the service was recommended and it helps you improve in a school and vocational setting, or if it helps the child improve its social networks. So their expert described those components and says, these 11 components make up intensive behavioral services. The district court then took those components, and he only used 10 of 11. I think that was just a clerical error, but he used those components and said, any one of those 10 components listed by the plaintiff's expert, that means it's an intensive behavioral services. So taking that definition adopted by the district court, which wasn't advanced by either party or expert, then it means that if you look at the medical records, we know we're not going to find a child's been recommended for intensive behavioral services. Let's say the child's been recommended for something called psychosocial rehabilitation. Then the district court would have to look at that and say, okay, is psychosocial rehabilitation fall under any of those 1 through 10 components. Does it help a child improve their behavior in school? Does it improve their social network? If yes, then maybe that's an intensive behavioral service. And that's not an objective standard of which to identify class members. That's not straightforward, and problematically so. The way that the class definition is phrased, it says it pertains to Medicaid children who have been recommended for crisis services, intensive care coordination, and intensive behavioral services. So does that mean a child is a member of the class if they're recommended for any one of those services, or does there need to be a combination of all? A treatment plan for children is not going to be linear. Each child's going to have a different scope, amount, duration of services. And so also the district court read LDH's expert opinion regarding intensive behavioral services and concluded that the two experts agreed, and LDH strongly disagrees with that interpretation. Our expert agreed on the general description of intensive behavioral services, but did not agree that intensive behavioral services is a universal, single, billable service. And so we believe that was an error by the district court to find that conclusion in its amended class certification order.
And what is our standard of review if there was an error by the district court?
So the standard of review is for an abuse of discretion, but the appellate court will review whether or not the district court applied the correct legal standard de novo.
Let me make sure I understand. When we talk about billable services, is it possible that a class description could be put together that did not require billable services? Is that the linchpin that you're arguing, is that it must be a billable service, or are we reading too much into that?
That's a great question, Your Honor. So in plaintiff's briefs, they bring up the fact in support of typicality that LDH in the past has stipulated to classes where the plaintiffs have diverse disabilities. And their examples are AJ and Bartholomew. In AJ, no billable services were involved, and we were dealing with one specific service, which was in-home nursing. In Bartholomew, at that point in time, it was 20 years ago, so it was before Medicaid managed care, and there really weren't a robust set of home and community-based services, so the Bartholomew class was a specific identifiable population. We did not oppose class certification because at that time, LDH knew that it could be doing better. These were people who were in a nursing home. They wanted to be out in the community, but they needed that nursing home level of care. They applied for a waiver that would put them out in the community receiving that care, but there weren't enough waiver slots. So we had applications, we had people who were institutionalized. We knew that we could do better, and we were candid about taking accountability for that. And so if anything, AJ and Bartholomew show that, we will settle the lawsuit and we will agree to a class certification if it's appropriate at that time. Here, we don't have a specific population. The named plaintiffs aren't institutionalized. They're not on a wait list. They similarly have no application that would tie us all in. And the class conditions, unlike Bartholomew, are subjective, as we've previously discussed. That leads me into the cohesiveness requirement. So this is a B2 class. And so in order to meet cohesiveness, the plaintiffs need to be harmed in the same way, and the injunctive relief needs to be specific. So plaintiffs are seeking a single order requiring LDH to provide necessary and timely services. And the problems with that relief is that, one, the intensive behavioral services, that part of it is not specific as to what services qualify as intensive behavioral services. It doesn't specify a specific policy of LDH that violates the Medicaid law, the EPSDT mandate, and it doesn't give reasonable detail as to the acts that are required by LDH. So like this court found in Maldonado, plaintiffs can't provide reasonable detail, and that highlights the fact that the individualized issues overwhelm the class cohesiveness. We are asking the appellate court to follow its precedent. It's good precedent. It's clear and consistent precedent. Just like in MD versus Perry, there's no effort by plaintiffs to tell LDH what it would mean to provide an adequate level of services. If you read their second amended complaint, it broadly alleges that it's an inadequate system, that this is a defective mental health system, but it's not a specific practice, not a specific service by LDH that plaintiffs raise. And class-wide injunctive relief would necessarily require the district court to oversee an overhaul of the Medicaid system as it relates to behavioral health services. I see that my time is about to expire, Your Honor.
Thank you. Thank you. You've reserved 5 minutes. Ms. Coursolle?
Good afternoon, Your Honors, and may it please the Court. I'm Abigail Coursolle on behalf of the plaintiff appellees. Your Honors, I submit that this case boils down to two main issues: ascertainability and commonality. As to ascertainability, the district court implemented this court's clear instructions and certified a class seeking 3 services that have been recommended by a qualified provider. Now, everyone agrees as to the definition of 2 of those 3 services. And as to the third service, intensive behavioral services, almost everyone agrees. Our expert agrees, their expert agrees, and the district court agrees. The fact that defendants disagree as to the definition of that service is frankly irrelevant. As long as the district court understands that definition of that service and can apply it, then the class definition is ascertainable. Now, as to commonality, after remand, there's now just one legal claim at issue in this case. And again, the parties agree that the Medicaid Act requires LDH to provide intensive care coordination, crisis services, and something like intensive behavioral services, even though they don't agree on the precise definition of that service.
Counsel, is it fair to say that some people who fall within the class description are receiving all the services they're supposed to receive? Some are receiving partial, and then some, as you allege, are receiving none at all?
No, I don't think so, Judge Engelhardt. It is fair to say that some individuals in Louisiana's Medicaid program may be receiving 1 or 2 of the 3 services that have been recommended, but it is our position that no one is receiving all 3. And it is really important that all 3 services are provided together, because only when all 3 services are provided together do children receive the therapeutic benefit of those services.
But the description that we're considering in this case doesn't make that distinction, though. It sort of captures everyone within that age group.
I think I see where you're going, Judge Engelhardt, and I think this goes to the point that Ms. Boudreaux brought up. Because of the word "and" in the class definition, we would certainly say that a child needs to be recommended for all 3 of the services in order to be a class member. Does that answer your question?
Yeah.
So going back to commonality, I want to make clear that the single question remaining here is whether the 20 services identified by defendant's expert satisfy their obligation under the Medicaid Act. So that's really the question here. You know, they raise in their brief these red herrings about whether a parent could refuse services or appointment wasn't available, but that's really not relevant to the EPSDT, the Medicaid Act question that's remaining, which is whether Louisiana's current Medicaid program offers the services that constitute the 3 services sought by the plaintiff class here. Turning to the cohesiveness argument that my friend on the other side made, Your Honor, here the plaintiffs are seeking an injunction ordering the state to modify its policies to ensure the provision of the 3 services that we're seeking. So that is a very specific injunction and would require modification of their existing policies. It is our position that currently the policy of the state is not to provide the 3 services that we're seeking. So that is the policy that we're asking to change, and that could be remedied with a very specific injunction that would require them to provide those 3 services to children under the age of 21 in their Medicaid program.
Is there anything more that the plaintiffs seek in the case other than an instruction to defendant to follow the law?
Well, it's more than just to follow the law, Your Honor. The injunction we're seeking would order the Louisiana Department of Health to provide for intensive care coordination, crisis services, and intensive behavioral services in their Medicaid program. So they would have to enact policies to make those services available, to put them on the menu, so to speak, and then to ensure that they're actually available to children in Medicaid. As the commonality question, Your Honors, this court previously recognized, following the Walmart decision of the Supreme Court in Re Deepwater Horizon, that even a single common question will do to satisfy commonality, and that is what we believe is raised here because the dispute between the parties has now come into focus as to a question of whether the services that are currently offered in Louisiana's Medicaid program are sufficient to satisfy their legal obligation. I want to briefly touch on typicality as well. The question for this court as to whether typicality is met is whether the plaintiff's claims have the same essential characteristics as the class as a whole. And here we believe that is satisfied. Defendants say there's no, again, come back to this idea that there's no specific policy or practice that's applied uniformly to the class. And that's just wrong. Here, the uniform policy is the policy not to provide the 3 services that we're seeking. And that applies to each member of the class. And the district court could resolve that question of whether the services are provided to the class on behalf of the class as a whole. Any defenses that would apply to the named plaintiffs are also typical and would equally apply to the class as a whole. Going back to ascertainability, Your Honors, I wanted to address the question raised about whether the services must be billable to meet ascertainability. It is our contention that that plaintiffs need not show that the services sought are billable. Ascertainability simply requires that the class is adequately defined and that class members can be identified with reference to objective criteria. However, that's a bit of a moot point in this case, Your Honor, because our expert has testified that intensive behavioral services is a billable service, and testified that in his home state of Ohio, it can be billed in Medicaid as a single service. And their expert never disagreed with that. So here we've established that intensive behavioral services is a billable service that can be billed, is billed in other state Medicaid programs, and therefore it's ascertainable.
Do you view the class as consisting of those people who, in other words, like a snapshot in time, those people who fall within this description at the time of certification, or are you arguing that this is an ongoing process? When we talk about ascertainability, people are achieving the age of 21, in which case they're now outside the class description, and likewise, people after this certification will be recommended for certain treatments and therapies. They would be joining the class at a later date? In other words, is this a moving target?
Well, yes and no, Your Honor. I mean, this is a B2 class that we're seeking. We are seeking only prospective injunctive relief. And the comments to Rule 23 specifically note that B2 classes are appropriate where the class is not capable or is not readily capable of specific enumeration. And I think that's the case here. As you say, the people who might be members of the class today may not be the same people who will be members of the class if we proceed and are successful in obtaining an injunction a year or 2 years from now. But I think what the ascertainability requirement of Rule 23 requires is that at the time that injunctive relief becomes available, that the court is capable of ascertaining who is entitled to that relief at that time. And certainly, once an injunction is in place, it will continue to benefit people into the future, maybe even people who are not yet born, because those services will then be available in the Medicaid program, and they'll be available to anyone who needs them and who has a recommendation for those services and is under the age of 21.
What sort of time frame would you put on the existence of the class? I mean, you're asking the district judge to basically administer prospectively the implementation of policies, as I understood your argument. Is there any outer boundary of time, or is this still sort of an ongoing administrative responsibility of the court?
Certainly not, Your Honor. I mean, I think the responsibility of the court would be to implement the injunction and ensure that it's fully implemented. At that point, I don't expect that the district court would retain jurisdiction. We would trust Louisiana to administer the program in accordance with the injunction, and of course, people could come back into court if that weren't the case. But we're not seeking some kind of open-ended, ongoing obligation here. We really just want those specific policy changes needed to ensure that the 3 services we're seeking are available to the plaintiff class.
Can we go back to ascertainability?
Certainly.
As I read our court's prior panel opinion, the concern about intensive behavioral services, well, really concerned about all of them, but we were continued to have the concern about intensive behavioral services, is that essentially it requires judgment calls to be made. It's as to what falls within that term. What's not clear to me is why that same problem doesn't exist under the district court's definition.
Well, Judge Ho,
Doesn't it still require, I mean, how do you know what improves youth and family functioning, what prevents out-of-home placement? These all still require judgment calls, don't they?
I don't think so, Judge Ho, and I would disagree that that was the concern of the panel that previously decided the case.
Well, but what the court said was it is not clear which of these services are intensive, which fall within the definition, which don't. And of course, knowing which services are encompassed is essential to evaluating whether an individual is a class member.
Certainly. And that's exactly why we sought additional discovery before the district court so that we could put on more information about the specific services that we were seeking to ensure that this class is ascertainable. We fulfilled that obligation. It is now possible to go through an individual's medical records and determine whether that child has been recommended for intensive behavioral services. You know, this is similar to any other medical service, well, maybe not any other medical service, but most other medical services, Your Honor. If you think of something like an inpatient hospitalization, that is something that can encompass many components. You may be hospitalized because you broke your arm falling off your bike, and you may have to get some x-ray services. You may have your vital signs monitored. You may need to have an MRI. Those are all different components of the hospitalization, but that doesn't mean that the service itself, inpatient hospitalization, is not ascertainable. If I'm recommended to be hospitalized, that's something you can go and look in my medical record and understand.
Well, just so to follow up on your example, because I think it's helpful, I would think that a classic valid class action in this context would be, just to follow your example, every person who had obtained an MRI at a particular hospital during calendar year 2022, right? That sounds to me like an ascertainable class. The problem here is we don't have a term like that, MRI, or something that's very precise. Instead, it's this long definition that requires somebody to decide what services constitute. Are you saying that it's just obvious to all what will fall within these definitions? Because that's the problem I'm not able to get across. Maybe I'm just missing.
No, I take your point, Judge Ho. I mean, certainly intensive behavioral services is more of a term of art among...
I mean, you mentioned the Walmart v. Dukes case, and there are obviously a lot of Supreme Court cases where they've talked about the concern about mini-trials.
Right.
The whole concern about making sure we define the class and all the elements of a class is that we don't have these satellite proceedings fighting over the class. We're trying to get to the merits as quickly as possible. This strikes me as a classic mini-trial problem. Tell me why. Try to reassure me, if you can, that we're not that we're not devolving into these sort of separate satellite debates about what falls within these terms.
Sure, I'll do my best, Judge Ho. So I would say two things in response to that concern that you're raising. I mean, first is the district court specifically amended the class definition to be limited to those individuals who have been recommended for the services that we're seeking. And that was a choice specifically meant to get away from this mini-trial issue. As Ms. Boudreaux explained, for Medicaid to cover a service, the service must be recommended by a professional, and once that service is recommended, if it is a service that is coverable under the Medicaid Act, under 1905A, then that service must be covered. So here, the class is already limited to individuals who have been recommended for the service, and so there's no need to do any individualized determination of whether this particular child needs the particular service. That determination has already been made. The only question that's remaining here is whether the state of Louisiana has a legal obligation to cover that service in its Medicaid Act, whether it falls within the ambit of services that are required to be covered. Here, as I said, intensive behavioral services, it is a bit of a term of art. It is something that you may not be able to go to any individual on the street and they will not be able to define that service for you, but it is well known among mental health professionals, and that's why our expert as well as the state's expert both agreed as to the substance of the definition of this term. The district court found that it could go through individuals' medical records and look for each of the components. And this is just like the kind of keyword search that we do on Westlaw all the time, right? You enter the keywords, you do a search. If those keywords come up at maybe within some proximity to one another, then you can determine, okay, this is the case that meets my needs. In this case, you would be searching the medical records to say, okay, I see this is the recommendation for the service that exists in this child's medical records, making that individual a member of the class. As to the time frame,
Make sure I understand your argument correctly. It is the recommendation for services by the medical professional that makes it objective or that takes the subjective component out of it.
correct, Your Honor. So this isn't a case where we're asking to interpret anyone's state of mind, subjective beliefs. It's simply a question of, does this recommendation exist in the medical records or not? And that is something that can be determined with a manual review of those medical records.
And that wasn't included before the first panel.
Correct, Your Honor. Well, previously we were using one term to describe all three services together, and the previous panel determined that term that we were using, that umbrella term, was too amorphous and not clearly defined. They weren't sure what services existed within that term. That's what we've attempted to clarify before the district court, and that's before this panel now.
And do you agree that the 10 or 11, because I think there was some debate about whether or not there were 10 or 11 components, you agree that that was probably just a clerical error?
Yes, Your Honor. Yes, so our expert listed 11 components, and the district court seemed to have missed one of the components in the order amending the class definition.
Okay, so your theory is nobody needs to judge the particular merits of a particular service. The only issue is, was intensive behavioral services, have those in fact been recommended for a particular patient?
Correct.
Then why the whole definition?
I'm sorry, Your Honor?
Why, if it's just a magic words test, just every patient attached to a document that has these three words, if it were that simple, why the need for this definition? That strikes me as far more subjective.
Well, Your Honor.
See what I'm saying? If this were what the district court were doing, what you're saying, I would think that the class definition would be drafted very differently.
How so, Your Honor?
Well, every patient for whom intensive behavioral services were recommended. What we get instead, as I understand it, is a further medical definition of what intensive behavioral services are, not simply a word search.
Well, Your Honor, I think it's a bit of both. Certainly, if someone has a recommendation in their medical record that says, I, medical provider, recommend this child for intensive behavioral services, we would submit that that is sufficient to satisfy the class definition and that that individual is a member of the class if they're also recommended for the other two services we're seeking. The district court, I think, found that in addition to just using the three words, the name of the service, because this is a service that is sometimes called different things in different places, that it would also be important to look at the underlying components to determine whether there's an actual recommendation for the
So
service.
why doesn't the need for judgment calls creep in there? So it's, in other words, it's not just a word search, it's also a more sort of, I'm trying to avoid the word subjective because that sort of rigs the conversation, but it would seem to me that if it's not just a magic word search, then it requires the judgment, requires somebody to make the judgment that certain services being recommended fit within these categories.
I disagree, Your Honor. I think it's just a more complicated word search. You're looking for more words, but it is still, at the end of the day, a word search. If the words that are within the components are in the medical records, that's a recommendation for the service. So it may be a complicated Boolean search that requires some ands, but it is still ultimately just a word search. I see I'm almost out of time. I just wanted to quickly address Ms. Boudreaux's argument about Maldonado and the injunction sought there, and distinguish that the injunction we're seeking here is much more specific This really goes, I think, ultimately to the same conversation we've just been having about ascertainability. If the 3 services we're seeking are ascertainable and objective, then an injunction that orders Louisiana to cover those 3 services in its Medicaid program is equally understandable and objective. So in Maldonado, this court took issue with an injunction seeking mutually affordable health care because it wasn't sure how it would determine whether that health care was affordable, what it meant to be mutually affordable. Here, because we're seeking an injunction that orders 3 specific services, if those 3 specific services are understandable, then that injunction is equally understandable and applies equally to the whole class. Thank you, Your Honors. We request that you affirm the district court.
Thank you. Ms. Boudreaux, you've reserved 5 minutes.
Thank you, Your Honor. So just to briefly address that Maldonado case, we believe in Maldonado the word problem was reasonable, whether the medical service recommended was reasonable, and that was a subjective issue with the class. For us, we have a similar problem. We're talking about whether that service is intensive rather than reasonable. So we do think that there is a strong parallel there with the Maldonado case. I briefly want to touch on, well, not necessarily briefly, I want to touch on ascertainability and just clarify that LDH's position is not that the services at issue have to have billing codes in order to be ascertainable. Billing codes certainly help make it more identifiable because, for instance, in discovery, we can pull data on all those billing codes that were billed for each Medicaid recipient and show what services were actually provided and utilized for that child. But the district court here, this court has actually considered these 3 subterms before in the first appeal. To be clear, the district court changed the class definition from those that pertain to those recommended for intensive home and community-based services to those who are recommended for the 3 subterms, which are intensive care coordination, crisis services, and intensive behavioral services. Those are not new terms. In fact, the Fifth Circuit's opinion in the first case cites that those specific services are not specific billable services, and LDH does not now argue that those are specific billable services. They are now ascertainable only because 2 of the 3 of them, we've come to an agreement as to the specific services for the purposes of this litigation. So 2 of them are ascertainable, but the 3rd, intensive behavioral services, is not because we can't agree on what that term encompasses, and we don't believe that that is a universal term that even a Medicaid person on the street would know what services you're talking about would fall under intensive behavioral health. So for instance, psychotherapy, is that intensive? For one child, it might be intensive. It might be all that they need. Maybe they're going to psychotherapy, they're seeing their therapist several times a week, and so that frequency of the psychotherapy is making it intensive. But for someone else, it might not be. Or there are different types of psychotherapy. There's different types of evidence-based practices. Perhaps you have the family with the child, and maybe having the family there or having the child's coach or teacher there in the room, that's giving it the intensive element. Each child's treatment is going to be subjective, and it's going to depend on their individual needs, what they're going to respond to, what's going to make their condition better. In the discovery proceedings, it has revealed the lack of rigorous analysis that was conducted prior to class certification being granted, because plaintiffs retain an expert that say, intensive behavioral services, you can find that in a medical record, but they have not set forth any evidence that any Louisiana person has been recommended for something called intensive behavioral services. They haven't specified it in saying, here, all of these billing codes that providers bill, we qualify that as intensive behavioral services. And they haven't named other specific services that maybe other states are providing that they would qualify as intensive behavioral services that Louisiana is not providing. So what happened in discovery is that plaintiffs adopted LDH's experts' reiteration of, here's 17 services that LDH Medicaid provides in the behavioral health realm that could qualify under that broad definition. And so now we're doing discovery on those 17 services plus the 3 other services that we stipulated to. So we have over 20 plus services, and LDH believes that you will not find another class action that has 21 plus services at play, and those services are not necessarily interrelated. Just because you're receiving one of those services doesn't mean you're going to receive the slew of other services. There's going to be different combinations and frequencies and amounts, and you're not going to find a class certification that's framed in the same way, because it would be completely unwieldy, unmanageable. You would have to have subclasses for each specific service. So what is the point in having a class action and having we don't have cohesiveness among the class members, because you're going to have to stop and look at the individualized issues often, which is going to prevent, a single injunctive order that could remedy all of plaintiff's harms. I also briefly want to note that the district court created a common injury that wasn't alleged. The district court found that that LDH has a policy of not providing any services. If that was what was actually alleged, that might be resolvable on a class-wide basis. But if you read the complaint specifically, you can look at paragraph 24 or 28 of the complaint. It's alleging that plaintiffs don't receive some services or enough services, and it's systematic deficiencies. So we respectfully request that this court vacate the district court's class certification order.
Thank you. The case is submitted and we are adjourned.